6. Yes?
In the second paragraph on page 6,
Yes?
where it says the committee had decided, which committee is being referred to?
It must be the CRC, but if you put committee, then it may be confused with the
That's
Joint
it.
Select Committee.
Right.
I'd
In
ask
which
that
case
the-
it should be recommended,
Yes.
not decided.
Yes,
Right.
yes. Thank you. So just to rephrase, the first sentence of the third paragraph, the procedure for the president's removal was akin to an impeachment process. Just ask that it be, yes. It was akin to, yes.
That second paragraph, Chair. I'm
Yes.
sorry. Is it the second paragraph? 1 second, I just lost that page.
Yes?
No, it's the penultimate paragraph. The chairman said that the committee we're talking about here is the Joint Select Committee. Yes?
Yes.
Okay.
This committee,
Okay, well, but yeah, a little clarity.
yes. So we changed the to this. If there is no other correction to page 6, we can confirm and go to page 7 as corrected. So I would ask that the sentence commencing, the chairman further explained that in examining Parliament's role, in respect of the office of the president, the CRC had decided on an activity that was simultaneously symbolic and substantial. The CRC recommended a process that was both symbolic and substantial. Highly symbolic, recommended a process that was highly symbolic as well as substantial. I would just revise the following sentence. Instead of at that time, there was no constitutional provision, simply to say that there was no constitutional provision for both houses of parliament to sit together. Yes. If there is no other correction, then as corrected, you move, confirm page 7 and move to page 8.
In the middle of the first paragraph,
Uh-huh.
let's see, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12th line. In the sentence she noted that the bill proposed that the panel be established by the parliament, but naming of such panels was often spearheaded by a portfolio minister. I think what I said was usually done by a portfolio minister.
Okay. So the proposed correction is that she noted. Can you just indicate the proposed correction? Replace
Sorry, you want me to
often
just state?
spearheaded with usually done by?
Yeah, was you, or just if you can say usually done by the portfolio minister, yes.
Okay. Very well. If there is no other correction to page 8 as corrected, we can confirm.
So there is, Chair, the
Yes.
last paragraph, which would be the second sentence. She posited that since the bill proposed placing the grounds for removal in the Constitution, it meant that if a president committed acts that fell within any of those grounds, the sitting president would have breached the Constitution. I'm sorry, it's the next sentence. She therefore asked why the body that would investigate was not a judicial body such as the Constitutional Court. The point I recall making was that I was asking why is that determination? Why is the determination of the breach of the Constitution not done by the Constitutional Court? I don't know that I was suggesting that the Constitutional Court should investigate, but that the Constitutional Court should determine what would be a constitutional breach.
May I ask Member Golding that you propose the correction that you
But let me think about it,
asking
because
for.
I'm just in the minute, so I don't want to delay you. I'll think about it and come back to you.
All right, we will come back to page 8. We go to page 9. I ask that the sentence commencing, she emphasized that impeachment scheme within a parliamentary system was problematic. That's the second paragraph of page 9. That the rest of the sentence be reworded as follows: and acknowledge the research done and the guidance provided by Dr. Barnett. And I just ask that where you put the committee, we would put this committee to ensure clarity, that the reference is to the Joint Select Committee. Yes?
The reference to Constitutional Reform Committee, CRC, appears previously, so you would have to locate the first instance where Constitutional Reform Committee is referenced, and that CRC flows therefrom.
Thank you. So remember, the minutes will be read by other people outside of this time, and it's important that they know. Right. So the first appearance of CRC, and I would say in each of the minutes, not just in this one, that we put both the full, because you want to make the reference to the minutes easy, and that people don't have to go back to a previous set of minutes to understand what CRC meant when those who would come long after are researching the matter. All right? Yes?
On page 3, first paragraph,
Page?
fourth line,
Page what? Same page 9?
page 3.
You're
The
asking-
CRC is,
Oh, it's on page 3.
yes,
you say.
at the fourth line,
All right.
first paragraph.
Thank you, Ms. Wilkins. Again, this committee's deliberation Member Golden, please check the last paragraph of page 9 to see if you would wish to have it reworded while maintaining. I don't know that it is necessary to indicate that a member interrupted the chair in order to make the point. I would prefer that it's not be reflected that way. Yes.
I don't have a difficulty with that, Chair.
Sorry?
I'm in agreement with you. I don't have a difficulty with
Yes,
what you just said.
just to say that Member Golding Campbell sought clarity. Yes. All right. That's corrected, and we go to page 10. Just to say for those looking on, sometimes going through minutes may seem tedious. And if you're watching, you may wonder what is happening. But records are important, and the accuracy of records are important. So I crave your indulgence and your appreciation of this part of the process, right? Yes?
Last line of page 10.
Yes?
The spelling of Sir Howard Cook's name, it needs an E.
Yes. It's not the one in the kitchen. Yes. Yes?
We could hyphenate the words Governor General,
Yes.
where it appears in the last line and on the remaining pages of the report as well.
Thank you, Madam CPC, and whenever it is written, for it to be so hyphenated. All right?
Madam Chair, I think I'm learning that for the first time. The Governor General is a hyphenated term.
Yes.
I don't think I ever knew that. Thank you for that edification. Can I just point you to the the fourth paragraph on 10? The second sentence, she asked whether based on the chairman's explanation, those grounds should instead be part of the bill rather than the Constitution. The point I was making is whether those grounds should be part of a law rather than.
Or a bill, a bill.
Or,
That's the-
yeah,
right.
I didn't want to confirm.
An act
I
of
didn't want to
parliament.
confuse it with the bill we're
Yes.
talking about.
An
And
act of
yes, an act of parliament rather
Yes.
than enshrined in the Constitution.
All right. Any other correction to page 10? If none has corrected, we can confirm and go to page 11. So again, I would ask that in capturing the discussion, it doesn't have to be captured in a way that it is a personalizing between the chair and one member, but that the gist of the contribution be noted. All right? Thank you.
Madam Chair, where,
Yes.
where are you referencing just now?
The chairman responded to Senator Golden by stating that based on the questions raised, she initially thought that the senator was heading towards a point similar to what Member Charles had previously asked. So that kind of, yeah, but that doesn't need to be put in the minutes. So simply that the chairman queried whether the point being made was similar. Right, just that. Yes?
I'd also add that where it is that we have references to the title being senator, that we keep it consistent with member, because member is what is being used throughout the document, and also in the committee.
Member, I mean,
Yes,
you could
my
use
name
member
said-
Senator Golden, but member, right. Yes.
Well, we've taken out that reference now based on the amendment that the chair just made.
Yes.
So yeah, that's fine. And my name to be consistent as well, please. Thank you very much.
You know, there is a true art to recording and note-taking, especially when they are official records. And it's always important to have consistency in reference to prevent ambiguity. Right?
You know, Chair, I long for the day when this process is unnecessary and we adopt what is commonly used now, the AI tools to just record meetings and summarize and provide minutes to meetings.
Work in progress, member Golden Campbell, work in progress. Yes, but we can be aided by technology, as we are now, which facilitates your presence from another space and mine in other meetings. If there is no other correction to page 11, we can, yes?
The reference to member Charles in the second line of the fourth paragraph,
Yes.
ought it not be member Sinclair? Yes.
You know, I too sometimes mix up the Christian and the surname,
Surname,
because
right.
both are used.
They are, yes.
Yes. So I'm going to expose the clerk. The clerk is saying that she was ably assisted by AI. And it took down Charles because the chairman said, Member Charles. So that is where it requires human intervention for accuracy. Yes. Yes. All right. So with those corrections, we go to page 12. Right, so the second paragraph, the chairman acknowledged that there was a tendency in the jurisdiction to equate an allegation with guilt or to believe that an investigation would automatically lead to a predetermined outcome. She highlighted that this was a challenge, making reference to a murder case in Clarendon, where despite overwhelming evidence, due process still had to be followed to avoid unjust conviction. That was not the point. She illustrated the challenge by referencing a case where there was overwhelming evidence that the accused had committed the act complained of, but it still required due process before a conviction could have been made. That's the point. It's an illustration of a principle with an example that analogously demonstrates it. If there is no other correction, we as corrected, and we go to page 13. Right, so the penultimate, or the paragraph, the chairman referred to regulations in the public service which prevented action from being taken against an officer or civil servant accused of misconduct. The point that was made is a prevention of action, disciplinary action being taken before the criminal process was concluded. So this does not capture the point. Or administrative actions, which prevented administrative before the conclusion of a criminal process where the person was charged. Yes. And it's actually the police service regulations. Conclusion of the legal proceedings. All right. There is no other correction to page 13 as corrected. We go to page 14. All right, if there is no correction, will someone move for the confirmation of the minutes as corrected?
Dwayne Smith.
Thank you. Seconded?
Seconded, Chair.
Thank you. Any matter arising? There would be matters arising, but I'm going to ask that they be deferred and we go to the continuation of review of the bill. Madam CPC, we're going to go to the provision in respect of the Parliament, the legislature. I think it's clause 15. Yes.
Thank you. 15, amendment of heading in Chapter 5 of the Constitution. The Constitution is amended in Chapter 5 by deleting the heading Parliament and substituting, therefore, the heading the Legislature. 16, repeal and replacement of Section 34 of the Constitution. Section 34 of the Constitution is repealed and the following substituted, therefore. 34, establishment of Parliament. There shall be a Parliament of Jamaica, which shall consist of the President, a Senate, and a House of Representatives, and which shall have the power to make laws pursuant to Section 48, including the power to make laws having extraterritorial operation. 17, Section 35 of the Constitution is repealed and the following substituted, therefore. 35, Senate. 1, the Senate shall consist of 27 persons who, being qualified for appointment as senators in accordance with this Constitution, have been so appointed in accordance with the provisions of this section. 2, 15 senators shall be appointed by the President acting in accordance with the advice of the Prime Minister by instrument under the broad seal. 3, 9 senators shall be appointed by the President acting in accordance with the advice of the Leader of the Opposition by instrument under the broad seal. 4, 3 senators shall be appointed by the President in the President's discretion from among persons in the private sector, civil society, faith-based or community-based organizations, or other sectors of the society. And in making any appointment under this subsection, the President may have regard to the representation by any such person of the interests of Jamaican citizens who reside abroad.
All right, I'm just going to ask that we pause. This proposed expansion of the Senate is implementing a recommendation to have in the Senate members who are not drawn from the political parties that contested general elections. So we know constitutionally the Senate has to be constituted as soon thereafter as general elections are held when the House is constituted. And this proposal is about independent senators. We have received quite a bit of feedback on it. I'm going to ask our Director of Constitutional Reform to just indicate some of the types of comments and feedback that we have received, even ahead of our calling on those who have made submissions to participate in the process. So the proposal is for an expansion in the Senate, and it would move from 21 to 27. 21 to 27. An important related matter is the vote that is required to amend the entrenched provisions of the Constitution. I made reference to the clause in the bill that the safeguard that currently exists is retained. During the deliberations of the Constitutional Reform Committee, much consideration was given to the significance of senators being backed by the organization, meaning the political party that contested a general election. So we know currently that by virtue of advice and recommendation coming from a prime minister and a leader of the opposition, that you expect affiliation with the political parties. And that brings a certain level of legitimacy in a democracy and in a parliamentary system. And it's important that that be understood. Mr. Harper?
All right, thank you, Chair. So having reviewed some of the submissions that would have been made by members of the public to the Joint Select Committee thus far, the general sentiment around the proposed expansion of the Senate is that there are some members of the public who are suggesting that it be a directly elected Senate rather than an appointed Senate. There are those members, and this is in keeping with their view of what democratic processes entail and what they understand and believe democracy to be and represent. Additionally, there are some groups who are of the view that a further expansion should be done. Right now, there's a proposal for 3 independent members, but some groups in particular would have suggested 6 independent members because they believe this to offer greater value in terms of a discourse among senators on legislation that is brought before them. And there are other groups who are of the view that the composition as proposed would be better arranged in an effort to guarantee the safeguard that is currently upheld throughout the bill by a different arrangement than what is proposed currently. So that's the general gist behind the submissions received thus far.
Thank you, Mr. Harper. Just to bring to the attention of members and those who are viewing that for many years, the political parties represented in the parliament have indicated to Jamaicans living abroad that they would give some form of representation to them in the parliament. And that has created a lot of discussion, a whole lot of discussion. But I think in an effort to honor the spirit of what is intended, the provision invites the president to have regard to the representation by any of the senators to be appointed in his discretion of the interest of Jamaican citizens who reside abroad. It is not the give that the diaspora is asking for, meaning that Jamaicans in the diaspora have asked, not unanimously so, for a member from the diaspora to sit in the parliament. But the parliament is like no other place, and you really can't be making laws and confirming policies for people in circumstances where you are not prepared to abide by them and live under them. But the policy of the government of Jamaica across administration is to partner with Jamaicans abroad, Jamaicans at home, and the formal machinery of government in the best interest of the nation of Jamaica. And I think this is what is being honored here in this proposal. Members?
Madam.
Yes.
Madam Chair, I I wonder if you could just speak to, I'm going to ask my two questions. I wonder if you could just speak to the rationale behind the numbers that that this is proposing. You know, why 27 and not another number? And then also, in subclause 4, sorry, in what is the proposed section 35(4), 3 senators shall be appointed by the president in the president's discretion from among persons in the private sector, civil society, and let me stop there. The private sector reference here, I'm assuming, is a reference to persons from the business community. What does it mean to be private sector? Not working for government, or persons in commercial endeavors that constitute private companies? What does private sector mean? Thirdly, who is civil society? And it's not the first time I've seen this reference, I would be at this point very opposed to the term civil society being introduced into the Constitution. I'm not aware that it is currently there, but I know I have seen it in some of our legislation, our acts of parliament, where bodies are being appointed, panels or tribunals or of that kind of nature, and a member is drawn from civil society. And I make this remark because I'm not quite sure I know what civil society is. Is that a voluntary organization operating in Jamaica? Is it an international organization operating in Jamaica that has local members? Who is civil society? And I would be highly concerned if the president had the ability to appoint a member from this quote-unquote civil society group whose interests were directed or influenced by a body outside of Jamaica. So I would wish some further explanation as to the rationale behind these categories chosen. And I would further say that the other category of faith-based or community-based organizations, again, I'm making the same point. If you say a faith-based organization, I hope we mean that that's a faith-based organization operating in Jamaica, constituted in Jamaica, with local members. And community-based, I'm assuming, is our local community in Jamaica. But please, I welcome further explanation.
Senator Golden, you have a way of raising some interesting questions. Throughout the Constitutional Reform Committee process, we deliberated on the significance of references in the Constitution. It was not in relation to civil society or faith-based organization, but we had it in relation to the Commonwealth, what it means, but in principle is the same thing. Before I answer directly, and I'm going to either ask the CPC or the Director Legal Reform to just help to guide how a provision like this would be interpreted, because statutory provisions are interpreted in a particular way using rules of interpretation, and there is a starting point with them. And also we have in the team members who have done work outside of government and can help to shed some light on the question you're asking. But I think it may be helpful to just share with the committee and the public some of what the committee had in mind. So going to the report, the report of the Constitutional Reform Committee, which was tabled in the Parliament as ministry paper. On page 29 at paragraph 7, we have composition of the Senate, and 7.1, increase of membership. The CRC took note of the recommendation of the Joint Select Committee on Constitutional and Electoral Reform to increase the membership of the Senate. It further noted that in the past, there have been many other proposals for altering the composition of the Senate, as well as the manner of appointing its members. The CRC does not consider that there is any need for radical alteration of its composition, but agrees that some provision should be made for the inclusion of persons who are not aligned with the government or opposition parties, and who would be able to exercise independent judgment on all issues. Accordingly, the CRC recommends that the size of the Senate be increased from its present membership of 21 to 27, appointed by the President as follows. 1, 15 members on the recommendation of the Prime Minister, 9 members on the recommendation of the Leader of the Opposition, and 3 members in the President's discretion from among outstanding persons in the private sector, civil society, faith-based or community-based organization, or other sectors of society as the President may consider necessary. So the recommendation has been implemented in almost exact term as the recommendation of the CRC. It doesn't mean that it had to be that way. It was a convenient way of doing it. But the essence of it is persons who are not affiliated with the government or opposition parties reflected in the Parliament. Now, the Constitution does not specifically reference political parties, but we know that the electoral laws authorized by the Constitution do so. And so we have an indirect referencing. What came to my mind, Senator Golden, as you posed the question about the inclusion of the listed groups, is whether the intention could be achieved without referencing the groups, although the referencing was done really to signal where they can be drawn from. But you ask a number of questions. Madam CPC, you want to assist with the starting point for the interpretation of the provision.
Chair, one
Yeah.
second before CPC
Yes.
opines, can I just say one thing further? And this is in relation to the reference of civil society. That reference has become a reference that represents actually some specific groups in Jamaica now. So, and this is just by practice, that whenever the Parliament is talking about civil society and we talk about writing to get submissions, we have some named groups that we write to, you know, who've sort of been generalized as this is civil society. Fact is that any group can form on any mandate looking at any specific issue and be a part of civil society. And I would just, so my discomfort is that it is, that there's no real criteria for being civil
in certain
society.
groups that they are the ones from which an independent senator should be drawn.
Well, my concern is that I don't know that that's an independent senator. That's my concern.
You know, I always hesitate when I use the word independent, but in the context of the recommendation, it's persons who are not aligned with the government and opposition sides of the Parliament, really.
And again, Chair, I don't know if that is true of civil society groups in general.
No, I understand the point, Member Golding Campbell. I understand the point, and as you raised it, it had me thinking. But let us have the CPC weigh in.
Yes, so insofar as they are not defined in the Constitution or in this bill, those terms would have their ordinary meaning. So private sector would mean businesses outside of government businesses. Civil society would mean any group other than a private sector group or a government group, and that's the ordinary dictionary meaning. And then, as the chair indicated, these terms are really providing guidance because the closing words there make it clear that it's the possibility of appointment is open to other sectors of the society. So those listing those groups are merely to provide guidance.
I was wondering whether we could achieve the same goal by indicating that these other members could be drawn. The Senate shall be appointed. 3 senators shall be appointed by the President in the President's discretion from. It's really persons
Chair,
who are
why are you
not.
making it so complicated?
No, I'm thinking through.
Why don't just leave it to who in the president's discretion he considers to be independent persons not affiliated with the political parties? Because since it is the president's discretion.
That's where I
being
was going,
exercised.
Senator
Yeah.
Golding Campbell. I was just making a link back to the recommendation, which speaks to the non-alignment with the government and opposition sides of the parliament.
Right.
Yes.
And Chair, could you also include too the requirement that the persons, well, no, you wouldn't have to include it because the requirement to become a senator means you would have to be one citizenship in Jamaica. So it's understood. Okay.
All right, let's have some other perspective.
Yes, thank you, Chair. In listening to contribution made by CPC, basically to affirm that this is to provide guidance to the President in who he appoints as independent senators, I thought it would be helpful to look at what other jurisdictions would have done in relation to their composition of the Senate. And Barbados, of their 31 senators, provision is made for 9 who shall be appointed by the President in his discretion from outstanding persons from economic, social, or community organizations or other major fields of endeavor. And for Barbados, their section 36, 7 senators shall be appointed by the President acting.
No, you're saying Barbados twice.
Oh, sorry. The earlier one was Trinidad, 31 senators. And for Barbados, 7 senators appointed by the President acting in his discretion by instrument under the public seal to represent religious, economic, or social interests or such other interests as the President considers ought to be represented. But I think the framing that is proposed here is also mindful of our realities and terminology and what persons generally understand in our society to be categorizations of different groups as reflected and represented.
All
I
right.
like that, Chair.
Sorry?
I like either one of those.
The interests being represented.
Interest as opposed to the group.
All right.
And I can tell you, I watch the Trinidadian Senate quite regularly, and have had occasion to also watch the Bajan Senate. And the independent senators are very active. So that the contributions made in their senates, in their, it is robust, and it's not necessarily dominated by government and opposition.
Thank you, Senator Golden. So we will flag this for some revision in the language while achieving the intent of the recommendation to expand the Senate's composition beyond those who are aligned with the 2 political parties. as I listened to Mr. Harper, the thought occurred to me that some people believe that there's hardly anyone in Jamaica who's not aligned some way, shape, or form with the political process. But we know what we're seeking to achieve. All right, and just to also say that definition of the term civil society beyond the ordinary dictionary meaning is one that remains problematic in many spaces, since in some societies the view is that some groups may capture the space and the conversation space. It's just part, the intention is to broaden the composition and to introduce other perspective beyond those that are aligned with with government and opposition in the parliament.
Here, can I just make a further comment? Because I've thought about this issue. It's not the first time that it has confronted my mind. But, you know, the essence of civil society, for me, are advocacy and lobbying groups, i.e. groups that remain outside of the structure of government who advocate for different interests, right? So to use them as a category, to then become a part of the very legislative process, to me, destroys the civil society nature of that group. So I just offer
Very
that.
profound point, Senator Golden Campbell, a real profound point. And that's why just publicly sharing perspective is so important. You have me immediately thinking whether it may compromise the work that they do instead of help it, and compromise their voice, because then they become part of the decision-making process. But as part of the innovation, we kind of took that into account, and that is why the vote, the safeguard vote, would be maintained as is, which requires the government and opposition's participation. So we kind of thought it through, even though it may have been reasoned a little differently. It's really intended to give a different legitimacy and a space to the issue, but that the safeguarding of the Constitution would still fall on the shoulders of those who are aligned to the democratic election process.
I don't know how you can say that they wouldn't be aligned to the democratic election process in the Senate, the independent persons you're talking about.
What I mean is the affiliation with the parties that would have contested, because the recommendation is being made by the Prime Minister, who would have come from the ruling party, the opposition leader who would have come from the minority party. Mm-hmm. Another set of concerns have been raised about the composition, and that was whether it would shut out third parties. It would shut out third and other parties.
I was thinking of that earlier, and yes. I felt so too. I mean, in the formulation that is currently in the bill, I think it would, because you've named the three categories. I guess you say, or other sectors of the society, but I'm not sure that would contemplate another political party. But in any case, Madam Chair,
well, opposition more widely as those, it can be a combination of everybody else that does not support the government in the sense of how it is supported, but you still, for good governance, would have someone leading that pack.
Right. Well, like I said, I like the formulation that you headed towards in relation to interests that the president would consider, interests of religious community, interests of commercial community, whatever, diaspora, whatever, as opposed to naming of the group. So when the team comes back with a suggested formulation, I suspect we will have a discussion again.
All right. So we now go to the next clause, which speaks to the citizenship criterion. Indeed. Madam CPC?
18, amendment of section 37 of the Constitution. Section 37 of the Constitution is amended by repealing subsection 1 and substituting therefore the following. 1. Subject to the provisions of subsection 2, a person shall be qualified to be registered as an elector for elections to the House of Representatives if, and shall not be so qualified unless, that person is a citizen of Jamaica, resident in Jamaica at the date of registration, and has attained the prescribed age.
All right. So there you go. There is an alignment between your qualification to vote and your qualification to be nominated for elections or appointment. And it is Jamaican citizenship, not Commonwealth citizenship, but Jamaican citizenship and attainment of the prescribed age. The age for voting is actually 18, but for membership in the House is 21. Next.
Section 39A of the Constitution is amended by deleting the words Commonwealth citizen and substituting therefore the words Jamaican citizen. 20, amendment of section 40 of the Constitution. Section 40 of the Constitution is amended A, in subsection 2 by deleting paragraphs D and E and substituting therefore the following. D, subject to subsection 3, and these are the disqualifications from membership. 1 is under sentence of death imposed by a court of competent jurisdiction, whether in Jamaica or elsewhere. 2 is serving a sentence of imprisonment by whatever name called, of or exceeding 6 months, imposed by a court of competent jurisdiction, whether in Jamaica or elsewhere, or substituted by a competent authority for some other sentence imposed on that person by such a court, or is under such a sentence of imprisonment, the execution of which is suspended. Or 3, has been convicted by a court of competent jurisdiction, whether in Jamaica or elsewhere, of an offense involving A, treason, or B, fraud or violence, and the penalty imposed on that person is a sentence of imprisonment for a term of or exceeding 18 months. E, has been adjudged or otherwise declared bankrupt under any law in force, whether in Jamaica or elsewhere, and has not been discharged. And B, by repealing subsection 3 and substituting therefore the following. 3, for the purposes of paragraph D of subsection 2, A, where a person is serving 2 or more sentences of imprisonment that are required to be served consecutively, that person shall, 1, in the case of subparagraph 2 of that paragraph, throughout the whole time that the person so serves, be regarded as serving a sentence of or exceeding 6 months if, but not unless, any one of those sentences amounts to or exceeds that term. 2, in the case of subparagraph 3 of that paragraph, throughout the whole time that the person so serves, be regarded as serving a sentence of or exceeding 18 months if, but not unless, any one of those sentences amounts to or exceeds that term. And B, no account shall be taken of a sentence of imprisonment imposed as an alternative to or in default of the payment of a fine.
All right. Just for the benefit of everyone, Section 40, as the CPC indicated, is a provision dealing with the disqualification for membership of the Senate and the House of Representatives. So the first subsection which is being retained, provides that no person shall be qualified for election as a member of the House of Representatives who is A member of the Senate, B, is disqualified for election by any law for the time being in force in Jamaica by reason of his holding or acting in any office, the function of which involves any responsibility for or in connection with the conduct of any election or any responsibility for the compilation or revision of any electoral register. And then subsection 2, which is now being repealed and replaced, speaks to the disqualification in respect of so no person shall be qualified to be appointed as a senator or elected as a member of the House of Representatives who is Madam, should the chapeau have been carried over since it's the entire subsection that is being replaced? Yes.
Replacing two paragraphs, so it's paragraphs D and E?
Paragraphs
D and E,
D and E.
yes.
Right, okay. All right. So if you're under a sentence of death by a court of competent jurisdiction, then you are disqualified. And if you are serving a sentence of imprisonment of or exceeding 6 months imposed by a court of competent jurisdiction, or if you're under a sentence of imprisonment, even if the execution of the sentence is suspended. One question that has arisen tangentially from this matter, team, is what is a custodial and a non-custodial sentence? It's a matter that we may need to clarify. So in the context of this provision, there is no doubt that if the sentence is suspended, it is still regarded as a custodial sentence. But under the sentencing guidelines in the court, there is some controversy as to whether a suspended sentence ought to properly be viewed as a non-custodial sentence. And I'm wondering whether we should use the opportunity to have this matter clarified beyond the narrow provision. Because here the disqualification is serving a sentence of imprisonment. And even if you're under a sentence of imprisonment, the execution of which is suspended once it meets the threshold. I'm going to just note it because it's a matter that requires some clarity because consequences flow from custodial sentences. All right. The new inclusion for the disqualification provision is the fraud or violence, and of course, the penalty that is imposed will be an indication of the gravity. How grave is the example of the offense for which the person has been convicted? So we specifically make the provision in terms of the penalty imposed in respect of those offenses. All right? But if you are convicted by a court of competent jurisdiction, whether in Jamaica or elsewhere, for violence, an act of violence, and the penalty imposed is a sentence of imprisonment for a term of or exceeding 18 months. So the question is whether you are disqualified, whether or not you're serving the sentence, and after you're serving, if you are a convict who having been sentenced to imprisonment for a term of or exceeding 18 months. it's a slight difference is if you are serving a sentence of imprisonment, because naturally you would be taken away. And if you are not serving it, but the suspension is executed, you'd still be liable to serve it in the event of a breach. But this is saying that if you have been convicted and you have been sentenced to that, you are disqualified. It's not whether you are serving it. All right? So we have to be clear that is what we intend. But, Jamaica has too many cases of violence. And we really pass laws for peace, order, and good government. And we're saying no to violence for membership of the Parliament, in the Parliament. All right, we go to clause 21, if there are no other comments. Any comment from the team? All right. I see the drafters are deliberating. I will allow you to deliberate and share. The good thing about reviewing a bill this way is that you get an opportunity deliberately to consider what the intention of Parliament is. Mind you, that is to be done in any review, but the joint select process does it a little differently. You wish to share anything from your deliberation, Madam CPC? All right, that's for the drafters. All right, we go to clause 21.
Amendment of Section 41 of the Constitution. Section 41 of the Constitution is amended in subsection 1D by deleting the word Commonwealth and substituting therefore the word Jamaican.
Just for the benefit of in effect, no, if you cease to be a citizen of Jamaica, as opposed to ceasing to be a citizen of ceasing to be a Commonwealth citizen. So currently the seat of a member of either house shall become vacant upon the next dissolution of Parliament after he has been appointed or elected, if he resigns the seat, if he is absent from sitting of the House for such period and in such circumstances as may be prescribed by the standing order of the House, if he ceases to be a Commonwealth citizen or takes any oath or makes any declaration or acknowledgement of allegiance, obedience, or adherence to any foreign power or state, or does concur in or adopts any act done with the intention that he shall become a subject or citizen of any foreign power or state. So your seat will become vacant if you cease to be a Jamaican citizen, or if you take any oath or takes any oath or makes, is it anti-declaration? Is there an error, printing error there in the Constitution? Yes. It should be any declaration. The D should be a Y. Yes. Or acknowledgement of allegiance, obedience, or adherence. Or you adopt any act done with the intention that you shall become a subject or citizen of any foreign power. All right, there's no room for conflicting allegiance. All right, so we have one other clause that we will read through, and then we will take a break after that. And that's clause 20 with a proposed amendment to section. We have clause 22, the proposed amendment to section 49. Madam CPC? Yes? It's a printing error. It should be any and not and. The old, yes. So that's a slip. Yes. There's a literal meaning to, you slip, make a little error. It doesn't require going through a process of amendment, but it can be corrected. Slip rule. Yes. All right, clause 22.
Repeal and replacement of Section 49 of the Constitution. Section 49 of the Constitution is repealed and the following substituted therefore. 49, alteration of this Constitution. 1, subject to the provisions of this section, Parliament may, A, by a bill for an act of Parliament introduced in the House of Representatives, and B, passed by both houses, alter any of the provisions of this Constitution, or, insofar as it forms part of the law of Jamaica, any of the provisions of the Jamaica Independence Act, 1962. 1A, a bill for an act of Parliament that alters any provision of this Constitution other than a provision specified in subsection 2 or 3 shall not be submitted to the President for assent unless a period of 14 days has elapsed between the introduction of the bill in the House of Representatives and the commencement of the first debate on the whole text of that bill in the House, and a further period of 14 days has elapsed between the conclusion of that debate and the passage of the bill by that House. 2, insofar as it alters A, Section 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 25, 26, 27, 48, 3, 66, 67, 67A, 82, 83, 84, 85, 86, 87, 88, 89, 90, 91, 94, Section 96, 2, 3, 4, 5, 6, or 7, Sections 97, 98, 99, Section 100, 3, 4, 5, 6, 7, 8, or 9, Sections 101, 103, 104, 105, Section 106, 3, 4, 5, 6, 7, 8, or 9, Section 111, 1, 2, 4, 5, 6, 7, 8, 9, or 10, Sections 112, 113, 114, 116, 117, 118, 119, 120, Section 121, 2, 3, 4, 5, 6, or 7, Sections 122, 124, 125, 126, 1, Sections 127, 129, 130, 131, 135, or 136, or the second or third schedule, or B, the Interpretation Act or Section 2A of this Constitution in its application to any of the provisions specified in paragraph A, and there's a printing error here because all the words now following should go back to the margin because they govern both paragraphs A and B. A bill for an act of Parliament under this section shall not be presented to the President for assent unless a period of 2 months has elapsed between the introduction of the bill into the House of Representatives and the commencement of the first debate on the whole text of the bill in that House, and a further period of 2 months has elapsed between the conclusion of the debate and the passage of that bill by that House. 3, insofar as it alters A, this section, B, section 2, 24, 34, 35, 36, 39, 63, 2, section 64, 2, 3, or 5, section 65, or section 68, 1. C, the Interpretation Act or section 2A of this Constitution in its application to any of the provisions covered by paragraph A or B, or D, any of the provisions of the Jamaica Independence Act 1962. A bill for an act of parliament shall not be submitted to the President for assent unless 1, a period of 2 months has elapsed between the introduction of the bill into the House of Representatives and the commencement of the first debate on the whole text of that bill in the House, and a further period of 2 months has elapsed between the conclusion of that debate and the passing of that bill by that House. And 2, subject to the provisions of subsection 6, the bill has, not less than 2 months nor more than 6 months after its passage through both houses, been submitted to the electors qualified to vote for the election of members to the House of Representatives, and, on a vote taken in such manner as Parliament may prescribe, the majority of the electors voting have approved the bill. 4, a bill for an act of Parliament under this section shall not be deemed to be passed in A, the House of Representatives, unless at the final vote thereon, 1, in the case of a bill to which subsection 1A applies, the bill is supported by the votes of a majority of all the members of that House, or 2, in the case of a bill which alters any of the provisions specified in subsection 2 or 3, the bill is supported by the votes of not less than 2/3 of all the members of that House. And B, the Senate, unless at the final vote thereon, in the case of a bill to which subsection 1A applies, the bill is supported by the votes of a majority of all the members of that House, or 2, in the case of a bill which alters any of the provisions specified in subsection 2 or 3, the bill is supported by the votes of not less than 2/3 of all the members, constituting the members appointed on the advice of the Prime Minister and the members appointed on the advice of the Leader of the Opposition. 5, if a bill for an act of Parliament which alters any of the provisions specified in subsection 2 is passed by the House of Representatives, A, twice in the same session in the manner prescribed by subsections 2 and 4A, and having been sent to the Senate on the first occasion at least 4 months before the end of the session, and on the second occasion at least 1 month before the end of the session, is rejected by the Senate on each occasion, or B, in 2 successive sessions, whether of the same Parliament or not, in the manner prescribed by subsections 2 and 4A, and having been sent to the Senate in each of those sessions at least 1 month before the end of the session, the second occasion being at least 4 months after the first occasion, is rejected by the Senate in each of those sessions, that bill may, not less than 2 months nor more than 6 months after its rejection by the Senate for the second time, be submitted to the electors qualified to vote for the election of members to the House of Representatives, and, if on a vote taken in such manner as Parliament may prescribe, 3/5 of the electors voting approve the bill may be presented to the Senate for assent. Presented to the President for assent. 6, if a bill for an act of Parliament which alters any of the provisions specified in subsection 3 is passed by the House of Representatives, A, twice in the same session in the manner prescribed by subsections 3 and 4A, and having been sent to the Senate on the first occasion at least 4 months before the end of the session, and on the second occasion at least 1 month before the end of the session, is rejected by the Senate on each occasion, or B, in 2 successive sessions, whether of the same Parliament or not, in the manner prescribed by subsections 3 and 4A, and having been sent to the Senate in each of those sessions at least 1 month before the end of the session, the second occasion being at least 4 months after the first occasion, is rejected by the Senate in each of those sessions, that bill may, not less than 2 months nor more than 6 months after its rejection by the Senate for the second time, be submitted to the electors qualified to vote for the election of members of the House of Representatives, And if on a vote taken in such manner as Parliament may prescribe, 2/3 of the electors voting approve the bill may be presented to the President for assent. 7. For the purposes of subsections 5 and 6, a bill shall be deemed to be rejected by the Senate if A. It is not passed by the Senate in the manner prescribed by subsection 4B within 1 month after it is sent to that House, or B. It is passed by the Senate in the manner prescribed by subsection 4B with any amendment which is not agreed to by the House of Representatives. 8. For the purpose of subsections 5 and 6, a bill that is sent to the Senate from the House of Representatives in any session shall be deemed to be the same bill as the former bill sent to the Senate in the same or in the preceding session if, when it is sent to the Senate, it is identical with the former bill or contains only such alterations as are specified by the Speaker to be necessary owing to the time that has elapsed since the date of the former bill, or to represent any amendments which have been made by the Senate in the former bill. 9. In this section, A. Reference to any of the provisions of this Constitution or to the Jamaica Independence Act 1962 includes references to any law that alters that provision. And B. Alter includes amend, modify, reenact with or without amendment or modification, make such different provision in lieu of, suspend, repeal, or add to. 10. Notwithstanding anything in this section, a bill for an act of Parliament that amends A, subsection 1A, shall be deemed to have been passed in accordance with this section if the bill is passed in the manner prescribed in subsections 1A and 4, or B, subsection 2, shall be deemed to have been passed in accordance with this section if the bill is passed in the manner prescribed in subsections 2 and 4, and the bill contains only such alterations as relate to adding to or correcting any references made in subsection 1A or 2, as the case may be, to sections of this Constitution consequent on any alteration made to those sections.
Just go to 23, 24, 20, and then we'll come back to spend a little time on it. Yes.
23, amendment of section 55 of the Constitution. Section 55 of the Constitution is amended in subsection 3 by deleting the words Governor General signified by a minister and substituting therefore the words Minister with responsibility for finance. 24, amendment of section 58 of the Constitution. Section 58(5) of the Constitution is amended by deleting the words if practicable. 25. 25, amendment of section 59 of the Constitution. Section 59 of the Constitution is amended in subsection 2 by deleting the word Governor General and substituting therefore the words President, the former Governor General.
We're going to finish the part.
'26, repeal and replacement of section 60 of the Constitution. 60, enactment of bills. 1, a bill shall not become law until the President has assented thereto and signed it in token of such assent, and the President shall, on being presented with a bill for assent in accordance with this Constitution, so signify assent. 2, subject to the provisions of sections 37, 49, 56, and 57, a bill shall not be presented to the President for assent if and shall not be so presented unless the bill has been approved by both Houses of Parliament, either with or without amendment, or with such amendments as are agreed to by both Houses. 3, if the President does not signify assent within 30 days after a bill is presented for assent under subsection 1, the Speaker shall signify assent. 27, amendment of section 64 of the Constitution. Section 64 of the Constitution is amended, A, in subsection 2 by inserting next after the words subsection 3, the words and subsection 3A, and B, by inserting next after subsection 3 the following subsection. 3A, at any time when there is in force a proclamation by the President pursuant to section 20 declaring that a period of public disaster exists, The House of Representatives may by resolution passed by the votes of a 2/3 majority of that House, A, extend the period of 5 years specified in subsection 2 for a period not exceeding 6 months, and B, from time to time, further extend the period for not more than 6 months in respect of each extension, but shall not in any event extend the period of 5 years specified in subsection 2 for more than 2 years.
Yes.
Clause 26,
Yes.
the proposed subclause or subsection 3 to 60.
Yes.
I'm trying to remember, because I know it was a subject of discussion, whether it shouldn't be the speaker may, because in the event
Yes,
that the
may.
president
May.
had,
May.
yeah, okay,
May.
thank you.
Yes. Right. It really is just providing an avenue. Yes.
Absence of the president signifying assent. So I think it was intended to be shall.
May I, just a minute, All right. A query is made as to whether the power being given to the speaker to signify assent should be a mandatory power or a discretionary power. First of all, why is the power being given? The lawmaking process is given to the legislative branch of the parliament. Initially, we had contemplated restricting the parliament to the 2 houses of parliament. However, the system that we have is intricate, and because we are not reforming all provisions of the Constitution at the same time and not wanting to fall into error, we decided to revisit that recommendation until we have completed the full review of the Constitution. So we really are erring on the side of caution, right? Right. But just to go back to clause 20, I note the presence of Mr. Austin from the Attorney General's Chambers. Welcome, Mr. Austin. Have work for you as you come. I'm going to ask you to opine on clause 20 of the bill. '22, I keep saying 20, thank you, 22, which is a proposed revision to section 49. And just to say for those who are listening, section 49 of the Constitution prescribes the alteration procedure for the Constitution. It is complex and it is really not designed for the layman. And if the process is not in letter and spirit observed, any amending bill can be struck down, and we have had that in the past. The letter may have been followed, but not the spirit. So the provision has been interpreted in the case of Marshall Burnett. That was when there was an attempt to accede to the appellate jurisdiction of the Caribbean Court of Justice, and the process was rendered invalid because it did not comply with the spirit of Section 49, not the letter of Section 49. So just to say that currently the process to review the Constitution, alter it, is a complex process. It is not designed for the layman, all right? And not even every lawyer. It is designed for experts, because there is a level of soundness to the Constitution. Former Prime Minister described 49 as tying a belt around the waist of the Constitution. But you know, in addition to the lofty goals of repatriating the Constitution, meaning repealing the Imperial Order in Council and taking out of the Constitution from under that cloak, and in addition to transitioning from a monarchy to the republic, the proposed alteration of Section 49 is something that has the team excited because it should bring greater efficiency and less difficulty without compromising the safeguards of altering the Constitution. And specifically, it is being proposed to ensure that when we come to deal with the judicial branch of government, it can be done with greater legislative efficiency. So you will notice some important changes because constitutional reform in Jamaica has been a contentious issue. And every amendment of the Constitution has brought some controversy. So let us start from the start with what is being proposed. First of all, a bill to amend the Constitution must be introduced in the elected House of Representatives. First major change. The second change is that even if you are proposing an amendment to the least protected provisions of the Constitution, the amendment cannot be tabled and taken in a single day. Any amendment to the Constitution going forward, regardless of the type of provision, must be done deliberately and must allow time for parliamentarians to read and digest the bill. And so, a bill for an act of parliament that alters any provision of the Constitution other than the entrenched provisions shall not be submitted for assent unless a period of 14 days has elapsed between the introduction of the bill in the House of Representatives and the commencement of the debate on the whole text of the bill. And then a further period of 14 days has elapsed between the conclusion of the debate and the passage of the bill. Right now, that does not exist. Right now, that does not exist. But it really is in keeping with the very deliberate approach that must be taken to altering the Constitution, and also taking into account Jamaicans' feelings about their Constitution, and just providing guidance to parliamentarians. It's a good thing. This alone should have the opposition at the table. And then the leader of the opposition, a trained lawyer, misleading the parliament that the safeguards is being removed, when it says specifically that insofar as the entrenched and deeply entrenched provisions are concerned. Right? The vote in safeguard is in place. It's so wrong to mislead. It really is wrong. No amount of political mischief can excuse it. No amount of inciting confusion in a space. No amount of dissenting and wanting to have your own way can justify misleading the parliament and the public about what is contained in a bill. We can say we don't agree with it, but don't misstate the content of the bill. Otherwise, I'm going to conclude that you have not read it. Or if you have read it, you don't understand it. Or if you read it and you claim that you understand it, then you clearly intend to mislead. All right? Because it tells you specifically on pages 30 and 31 of the bill, clause 22, section 49. A bill for an act of parliament under this section shall not be deemed to be passed in the Senate unless at the final vote thereon. In the case of a bill which alters any of the provisions specified in subsections 2 and 3, those are the sections that set out what we describe as the entrenched and deeply entrenched provision. The bill is supported by the votes of not less than 2/3 of all the members, constituting the members appointed on the advice of the Prime Minister and the members appointed on the advice of the Leader of the Opposition. And I almost rose and took the point of order, but I paid courtesy because it was a debate. But it has to be, the record has to be set straight. We have to do better than that. Not because we're quarreling politically in an election year, or we want what we want, we're going to mislead the public. People listen to what we say and hang on to what we say. And we must make it a habit to be accurate. Not asking you to interpret. Accurately state what is in a bill, especially if you're learned in the law. All right. We also see proposed revision in the timeline to ensure that more can be done at a faster pace without being hasty in a legislative year. And we also see that if we are adding to the provisions or if we are altering for references purpose, we do not have to submit to the bill for a referendum. Major, major proposal for improvement and a demonstration of the administration's commitment to continue in the process of constitutional reform until we achieve the goals that we agree on. So to go to the people and say that you doubt whether it is going to happen because it never happened in the past, don't take the word for it. Look on the action being taken. I do not think that it is intended to do any further business. We would have essentially gone through all of the provisions, and now hereafter we will do the deep dive. So we are going to be then examining the submissions from members of the public. But before we come to do that, we are going to have a meeting of the Constitutional Reform Committee. May I be reminded, I do believe that if we did not go through the provision entrenching the Electoral Commission, then we can do so. Yes. If the record is that we did not, my recollection was different, but I'd rather we err on the side of caution. Don't think so. All right? Proceed.
So, 28, amendment of Chapter 5 of the Constitution and transitional arrangements. 1, Chapter 5 of the Constitution is amended by inserting next after Part 4 the following part. Part 5, the Electoral Commission. 67A, establishment of Electoral Commission of Jamaica. 1, there is hereby established a Commission of Parliament which shall be known as the Electoral Commission of Jamaica, in this part referred to as the Commission. 2, the objects of the Commission shall be to safeguard the democratic foundations of Jamaica by enabling eligible voters to elect through free and fair elections their representatives to govern Jamaica. 3, the functions of the Commission shall be to A, establish policies for governing the registration of electors in accordance with the provisions of the enactments relevant thereto. B, give directions to the person responsible for the day-to-day operations of the Commission on the performance of that person's functions under any law relating to the conduct of elections. C, 1, C, conduct 1, general elections or by-elections as the case may require of members to serve A, in the House of Representatives, B, on the council of a municipal corporation, or C, as mayor of a municipality. 2, referenda, which term shall be construed as including the procedure set out in section 49 for the submission of certain bills to the vote of the electorate. D, carry out any other activities necessary for the discharge of the functions set out in paragraphs A to C. And E, carry out such other functions as are assigned to it under this Constitution or prescribed by or under any other law. 4, subject to this section, an Act of Parliament may make provision in relation to the constitution, staffing, and resources of the Commission, and further with respect thereto, and the provisions of any such act concerning the quorum at meetings of the Commission shall have effect notwithstanding any provision of this Constitution concerning the quorum at meetings of commissions established by this Constitution. 2, the Electoral Commission of Jamaica and the members of the Electoral Commission of Jamaica, as constituted immediately before the commencement of this section, shall continue as provided for by the Electoral Commission Interim Act as amended by this Act. 29, repeal and replacement of Section 68 of the Constitution. Section 68 of the Constitution is repealed and the following substituted therefore. 68, Executive Authority of Jamaica. 1, the Executive Authority of Jamaica is vested in the President. 2, subject to the provisions of this Constitution, the Executive Authority of Jamaica may be exercised by the President either directly or through officers subordinate to the President. 3, nothing in this section shall prevent Parliament from conferring functions on persons or authorities other than the President. 30, change of name of Privy Council established by Section 82 of the Constitution and consequential amendments. 1, the Privy Council established by Section 82 of the Constitution shall from the appointed day continue and be known as the President's Council, and for the avoidance of doubt, its assets and liabilities shall be vested in the President's Council, so continued. 2, Sections 82, 83, 84, 85, 86, 87, 88, 89, 90, 91, 112, 125, 127, and 131 of the Constitution are amended by deleting the word privy wherever it appears, including in the marginal notes, and substituting therefore in each case the word presidents. 3, references to the Privy Council established under Section 82 of the Constitution in any law in force immediately before the appointed day shall from the appointed day be construed as references to the President's Council.
All right, so we would have gone through the bill, and then we're going to do the deep dive. I see from the submissions made in respect of the preamble, groups are asking for special naming and recognition, just to say that a lot of consideration was given to the preamble, and it's not possible to name every group. We thought that we could account for all those who wish to be named by a general reference, and also I think there is an ask about particular aspect of the history. The Maroons are asking to be recognized and named in the Constitution. Well, one grouping of the Maroons. And then we have different groups who are alleging to be the Taínos, to be referenced. But then we note from the submissions that there are different names. Ms. Mills, you would want to just indicate?
give me the time to bring it up. Yes, but that is true. We have multiple different groups, the Maroons, the Tainos, that are asking to be specifically named, and there are multiple different names as well. I'm also not sure if I can accurately pronounce all of these names, but I am looking for them. There's the Maroons, the Moors, the Tainos, as well as other groups that I'm not sure of how to pronounce the names of.
An indication of
try
how
to
excited.
pronounce?
Yes.
I was asking if I should attempt to pronounce the words. Okay, so we have the Ukayeke Yamaye Guani. That's a group of Taino.
You have to say it again so that Jamaicans listening can say whether they know of, are able to
The group.
identify this group.
All right. So the spelling is YukaYeke. That's the first word. The second word is Yamaye. And then the third word is Guani. That's one of the groups. All right.
And then we have the Maroons.
Yes.
I think I have to say that I don't know about another government constituted differently, but Jamaica is a unitary state, and it is not intended to create a state within a state. This is meant as no disrespect to the compound Maroons, but there is no state within the Jamaican state. There is a single Jamaican state, and we're moving to one republic out of many, one people. One people, one republic, one Jamaica. That is the road that we are on. Coexisting and respectful of the differences that we bring. All right? With our history of struggle, the road we have taken, and our aspirations. One people, one republic, one Jamaica. There will be no state in the state, no sovereign state of anywhere else but the state of Jamaica. We're not even changing the name to the Republic of Jamaica. It is Jamaica, the Republic, Jamaica, branded Jamaica, Jamaican or Jamaicanness. We're choosing Jamaica. And the choice is manifesting itself in many ways. But I want everyone to know just how serious we are about reforming government and reforming our laws to achieve our goals and our aspirations, and to create and reignite national pride in who we are as a people and who we can be, to mainstream excellence in our culture instead of having pockets of excellence, to have solid institutions run by people with integrity who understand accountability. It's all about serving the people in a better way. It's not just talk. That is what all of this work is. That is why we are bothering even when many others are distracted with so many other things, because the work continues. The journey continues. And it's not an easy road, but the journey continues. All right, so we will again meet next week when we will start looking at the submissions around the provisions. And just to say a big thank you to all who have taken the time to make a submission to the committee. We will send your thank you note. We are focusing on the submissions that relate to the provisions of the bill. Many of you have submitted on wider issues. Those other issues will come in the other phase to the reform work. So I thank you in advance for your understanding that if we chase 2 rabbits, we're going to miss them. We have to keep focus, and we really want to make progress in achieving this goal, so that when we come to the next celebration of independence and the nation is once again asked to reflect on what we have achieved since independence, we can collectively say we are making progress on this very, very difficult goal that we have set, and that we should continue the work. Is there any other business? So the date and time of the next meeting will be next Wednesday at 10 a.m. And on that note, I will terminate. I'm sorry? Wednesday, yes. And on that note, I hope there is not a conflict in the schedule for Wednesday. But on that note, I will terminate the meeting at 2 minutes after 1. Thank you all.
Watch the budget debates live on PBCJ. Jamaica's first female Minister of Finance and the Public Service, Favour Williams, will make her maiden presentation when she opens the budget debate at Gordon House on Tuesday, March 11. The government is proposing a $1.26 trillion budget for the 2025-2026 fiscal year, which begins on April 1. And her presentation will explain how it all will be financed. On Thursday, March 13, opposition spokesman on finance, Julian Robinson, will make his contribution. Opposition leader Mark Golding will make his contribution on Tuesday, March 18. Prime Minister Dr. Andrew Holness will follow 2 days later on Thursday, March 20. Then, Minister Favour Williams will close the debate on Tuesday, March 25. Watch it all live on PBCJ, the People's Station.
Most major illnesses that affect Jamaicans are caused by unhealthy lifestyles. Over 50% of Jamaicans are overweight. 1 in 3 Jamaicans has high blood pressure. 1 in 8 Jamaicans has diabetes. 17% of Jamaicans have high cholesterol. A healthy lifestyle can reduce the risk of most of these diseases. Things like regular exercise and adequate rest can play an important role in maintaining good health. The other major consideration is eating healthy. The question is, how do you walk into a restaurant or fast food outlet and identify the healthier menu items? Better For You is an initiative to help Jamaicans to eat healthier. Restaurants and fast food outlets can voluntarily participate by identifying